Okay, so let's get started with our next panel. Of course, an integral process of the Alaska Constitution has been emphasized both by Dean Chemerinsky, and our first panel is interpreting the Alaska Constitution. And a vital part of that is who we have as our judges, and so this panel is going to be focusing on the Alaska Judicial Council and the judicial selection process. And our moderator for this panel is Judge Larry Card, retired Judge Larry Card, who's also helping us out as an adjunct professor this semester teaching Introduction to Law here at UAA. We're very thankful to have him for that. He may not be thankful, but we're thankful. So with that, I will turn it over to Judge Card.
Thank you. Good morning. Many familiar faces. I'm sorry to get a chance to talk to you before we got started, but maybe I will. Marilyn, seen her many times, and other people in and out of court. David George is back there slinking somewhere in the back. He and I went through some battles together before I became a judge, Judge Ton. But anyway, welcome to this program. It's indicated that possibly I could introduce, maybe I'll let these people introduce themselves. And so I think we have the first speaker going to be on my left. So introduce yourself and tell us what we should hear about this matter.
My name is Brett Frazer. I'm a December 2017 graduate of the University of Michigan Law School. So I was a 3L less than a year ago, and here I am. I attended the University of Alaska Anchorage as a college student where I was a member of the debate team and was twice a national semifinalist and the second ranked speaker in the country. I say that to combat perhaps undermining my credibility with the previous statement. And it's a pleasure to be here. I wrote my article with Justice Walter Carpinetti, who many of you will know as the former Chief Justice of the Alaska Supreme Court. And I'd briefly just like to thank him. Without his Herculean effort, the article that we produced would not have materialized, and his feedback and mentorship was profoundly valuable. I learned more about writing and about the judiciary in the few months I worked with him than I did throughout my 3 years in law school. So big thanks to him. He has absconded to Italy and left me with presentation responsibilities.
Hi, I'm Susie Dosik. I'm the staff attorney for the Alaska Judicial Council. And I've been with the council, I think, 17 years now. And I've had the great privilege to have had the opportunity to really work with our judicial selection system to implement the goals of our Constitution.
Susie, unfortunately, we don't have a microphone, so if it's possible for you to speak louder, that would be.
Oh, I'm sorry. I have this this microphone.
That's a microphone for the.
Oh, for the camera. Okay, I'm sorry. I thought we were projecting, but I can do that. Does everybody can hear me? Okay, great.
Okay, as Brian said, I'm Larry Card. I was appointed by by Governor Hickel in 1993, and some of you may remember it was an interesting time. Governor Hickel, of course, was always a high energy, very interesting man. He and I had something in common. We both grew up in Kansas, and when my name and three others were presented by the Judicial Council that year, he didn't want any of them and made it quite public that he would rather pick somebody that he liked rather than this Judicial Council selection. And the Judicial Council advised him that he could not do that under our Constitution, under Article 4. And so they went back and forth, and I think there was some threat of litigation. Some of you in the audience may know about that. Myself and really capable people, Brant McGee, who was in charge of OPA, Mike Wolverton, who was a district court judge then, who was putting his name in the hat for Superior Court, and Peter Ashman, who was also a district court judge. And so all of our names were put in, but he didn't want any. And over a period of, if not weeks, at least days that turned into weeks, he decided he'd make a selection. So I received a call to go to the governor's office, and he and I spent most of our time talking about western Kansas. He grew up in Dodge City, Kansas, the old western town. I grew up in a place called Liberal, which is almost to Oklahoma. It's about 3 miles out the Oklahoma Panhandle. And so we spent most of our time talking about Kansas, and that was the interview. And that broke the deadlock, and it quieted out. And we haven't had any issues since that time, to my knowledge. You've been on 17 years?
We have had a few.
Maybe not so public.
Just a couple, yeah.
But anyway, I survived that process. Getting there was a little bit interesting. Some of the articles that have come out, or will be coming out in the law review, though, talk about the tie breaking that the Chief Justice has. His function is to break a tie. And the Chief Justice, when my name and 13 others were put in, he decided that he should be the tiebreaker, and he voted me in. Danny Moore was the Chief Justice at that time. And I had known him when I was in practice, but I never worked for him. He was part of the Delaney Wiles, Reitman Moore, Brubaker, some prominent lawyers who became judges came out of that office. But anyway, that was an interesting time, and shows how well our system works. Our merit system is supposed to produce not those who are just politically connected, but those who can do the job. And it was not as tough as my time had spent in the military, getting ready for all that training, but the process was dedicated. I'll put it that way, and never mean-spirited, always courteous. But the interview process, the process works. I like the articles, the drafts of the articles that came out about the lack of scandal and all the other issues that other states have had with judges who are politically appointed. So that's a short version of my experience with the process, and when I get a chance, I do speak in favor of it because many of our citizens don't understand this process, and they see a name, but they don't take time to read the Judicial Council's recommendations or all the information that goes into that. They really don't understand, so the education process for the electorate is very important. So, having said all that, I'll turn it back to you, sir.
So I'd like to do 3 things and some brief remarks in the interest of time. The first is provide kind of a crash course in the merit-based selection process for those who are potentially unfamiliar with it. The second is talk about the history of Article 4 and the historical and legal forces that led to the creation of a merit-based selection system in Alaska. And third, talk about some shortcomings that exist in the literature and potential areas for further research. So very, very briefly, Alaska's merit-based selection system moves in 3 phases. The first phase is nomination by the Judicial Council, which is a 7-member body comprised of 3 lawyers who are elected by the Board of Governors from the Alaska Bar Association, 3 members of the public who are appointed by the governor and confirmed by the legislature, and then the Chief Justice of the Alaska Supreme Court serves as an ex officio 7th member. These members serve staggered 6-year terms to ensure that the council cannot be stacked by one political entity or interest. And this first step really focuses on merit. To quote Ralph Rivers, who is a delegate to the Constitutional Convention, the Judicial Council will, quote, seek for the best available timber. And when the Judicial Council is reviewing applications, it uses 7 evaluative criteria, those being professional competence, integrity, fairness, temperament, judgment, legal and life experience, and then a demonstrated commitment to public and community service. I won't go into all the details of how the council carries out these responsibilities, but suffice it to say it's extraordinarily thorough. The second phase is appointment by the governor. And this strikes a balance between selecting the best possible timber, as Rivers put it, as well as satisfying the demands of popular sovereignty, the idea that the people should have some say in the composition of the bench, which rules when they are parties before the court. And then the final phase is the retention or rejection by the electorate. And the first retention election for any judge occurs no less than 3 years after they're initially appointed by the governor. And then depending on what level of court, where they serve in Alaska, there'll be retention elections as many as 10 years after that for members of the Supreme Court. So hope that provides some background and contextualizes the next point I'd like to make. So as has been a theme throughout this symposium, I think it's important to contextualize the drafting of Alaska's Constitution, and in particular Article 4, in history, and really place it in history. Professor Jed Sugarman, who is a professor at Fordham University, he published a book, a very exhaustive book that I read, which documented the evolution of the various court systems throughout all of American history. And Jed Sugarman points to the decades between 1950 and 1970 as, quote, the merit revolution. During that time, the Missouri Plan, which is the plan that I just described, although Alaska's has been modified from the original Missouri Plan, this plan spread through 19 states, and in addition to those 19 states that fully embraced the Missouri Plan, 9 other states adopted elements of that plan, whether it be the use of a professional council to select candidates for judgeships, or whether it be an apolitical retention system. In my review of the literature, I have found 4 historical forces that I think informed the creation of Article 4 as we have it today. The first is the American Judicature Society, which was a society that was kind of born of a desire to create robust, independent courts, satisfying the Hamiltonian vision of the separation of powers, a judiciary that would be insulated from the populist demands of the majority. That body, the Judicature Society, actually created the theoretical underpinnings of the Missouri Plan in the 1920s. And they did so largely in response to states frequently overturning their benches in the judiciary because elections were constantly forcing judges out. And the American Judicature Society thought this is not satisfying the Hamiltonian vision of an independent judiciary. The second force that Sugarman identifies is that political parties in states in the 1950s were worried about the populist uprisings that characterized the political arena during the Great Depression and World War II. As previous speakers have mentioned, labor unions became more powerful forces during the Great Depression, and those forces organized not only to elect politicians, but at times organized for or against particular judicial candidates. And so the merit selection system is, according to some experts, a response to those populist uprisings of the 1930s and 40s. Third, and somewhat cynically, business interests were concerned with labor litigation and labor unions' increasing success in judicial elections, and thus those business entities had a vested interest in securing merit-based selection. And fourth, World War II and the fight against fascism informed American thinking on individual rights and the expansion of judicial review. This was reinforced by the Cold War tensions. I learned constitutional law from a man named Richard Primus. He also serves as a mentor to me, and he's written extensively about this, explaining how it was very easy for Soviet propaganda to characterize the racism and classism of 1950s America as a terrible alternative to Soviet communism, and thus the intellectual elite in the United States did have a vested interest in using the courts as a vehicle to combat that when elections proved insufficient. Now, all of these forces can be viewed cynically. You can say, it was the intellectual elite and it was business interests and political parties, but I don't actually take that view. I think that you can observe the historical realities of these forces, yet give them a more generous interpretation. At the end of the day, multiple elements of American society, people using political parties as their vehicles, intellectuals, business interests, as well as the people themselves, all wanted and wished for a more independent and robust judiciary. To put it succinctly, all the parties that I've just talked about wanted good judges. They wanted judges who would be insulated from the demands of populism. So I don't think a cynical interpretation of those historical forces is necessary, though I do think it's important to acknowledge their reality. Turning now to Alaska specifically. Alaska was the first state to adopt merit selection in 2 respects. First, Alaska was the first state to adopt merit selection in all of its courts. And second, and perhaps more importantly, Alaska was the first state to really use merit selection as a pitch as part of statehood. As Herb Hischler mentioned, quote, "We have a product to sell. We had better make that Constitution pretty liberal if we are going to get into the Union." Now, when Hischler used the word liberal, he of course did not mean politically liberal, he meant classically liberal. He wanted a state that protected free markets, had a robust rule of law, democratic institutions, what you typically think of when you think of classically liberal. Now, this is important because what that means is that when Alaska's Constitution was created, it had to appeal to numerous constituencies. It had to appeal to Alaskans themselves, obviously. It had to appeal to a national audience that included both politicians as well as business interests, and it had to appeal to investors so that business would be attracted to Alaska. These forces are all important considerations in understanding why we have merit selection. Now, merit selection was not without its detractors. At the Constitutional Convention, the delegates to that convention voted overwhelmingly for merit selection. There was, however, a small minority who vocally opposed merit selection. That vocal minority, Robert McNeely, a delegate to the convention, spoke most powerfully. Now, I mentioned earlier that I was a debater, and so I really like kind of analyzing how people make arguments. And Robert McNeely is really frustrating because when you go back and you actually read the Constitutional Convention, he doesn't make straightforward arguments. He preferred to kind of posit these really elaborate hypotheticals. And so it's a little bit difficult to ascertain what his criticisms of merit selection actually were. In reading his comments many times, I uncovered what I believe are his two fundamental criticisms. The first criticism of merit selection that was brought to the convention was the power of incumbency. And this is not without theoretical merit. There are political scientists who study the incumbency advantage, and in an apolitical system where judges aren't challenged by another individual running for that office, there is some data to suggest that there's an incumbency advantage. However, I think the persuasive force of this argument isn't as relevant in the year 2018. The reason being is that in 1975, the Alaska legislature tasked the Alaska Judicial Council with evaluating candidates who were up for their retention election. So rather than the electorate being forced to determine on their own whether the judges were doing a good job, there is now a tremendous amount of data that voters can use and even participate in at hearings to be part of the evaluative process for those judges. So while I think that McNeely's arguments were perhaps relevant in the 1950s, I don't think that argument actually has much persuasive force today. The second argument is that members of the council themselves would be beholden to the interests of the entity that appointed them. So McNeely was concerned that lawyers would basically use the council as a vehicle to propel their own self-interests, whatever they may be, and that the individuals appointed by the governor would merely represent the political party or the political interests of the governor that appointed those members of the council. The data, however, doesn't really bear this out. Justice Carpenetti and I looked at a lot of documents from the Alaska Judicial Council, and we found that in 60% of the time when the council is evaluating a candidate, they vote unanimously. 80% of the time, they vote unanimously minus one individual. And in only 18 cases, which is 1.3% of those cases, was the council evenly split with 3 lawyers advocating for or against the selection of a judge, and the 3 lay members of the council advocating for the lay members of the judge. This means that in those cases, the Chief Justice of the Supreme Court would have to serve as a tiebreaker. But interestingly enough, in those 18 cases, 9 times the Chief Justice has sided with the lawyers, and the other 9 times the Chief Justice has sided with the lay members. So I just don't really think that, as an empirical matter, it's true that people on the council are simply there as kind of narrow, self-interested actors. Obviously, people who have been on the council or have experience with the council will want to express that they try to do the best job of selecting judges, and the data supports this conclusion. So to kind of wrap this up, McNeely had these 2 criticisms, but neither has been borne out in history, and neither, in our view, our being Bud and I's view, has proved to be meritorious. Now, there have also been challenges since the Constitutional Convention to the merit-based selection system. there has been a lawsuit, Miller v. Carpinetti, which challenged the merit-based selection system under equal protection grounds. Bud wrote this section of the paper, so I'm not going to go into too much detail, and any difficult questions you have, you can email him. But very, very briefly, both the District Court and the Ninth Circuit reached two conclusions. The first is that you can't really bring an equal protection challenge because the one person, one vote principle doesn't apply in Alaska because Alaska doesn't have elections. That's a pretty self-evident argument. But second, I think a close reading of the Ninth Circuit's case reveals something more fundamental, and that's the concern of federalism, that the people of Alaska ought to be able to craft their own judiciary in the image of how they see fit. And while the Ninth Circuit, which the decision was unanimous, by the way, never comes out and expressly says that, I think that that principle of federalism informs the entirety of that opinion. In addition to lawsuits, there has been attempts to amend Alaska's constitution. The most recent attempt was Senate Joint Resolution 21, which sought to modify the composition of the Judicial Council such that the governor would be able to appoint 10 members and the Alaska Bar would only be able to provide 5 members. I think the kind of cynical view here is that the governor is attempting to capture the Judicial Council. And there is some empirical research suggesting that when you give the governor, more control over the composition of a professional council, the judges whom that council appoints express more party bias. Now, let me be clear here. That doesn't mean that the decisions are worse. That doesn't mean that the decisions themselves betray party bias. What that means, though, is in states that have modified the composition of their professional councils, more judges, I'll use an example. In Florida, Florida had a system similar to Alaska's. They amended their constitution to provide the governor with more power. The governor happened to be Republican. The number of judges who were registered Republican who then made it to the bench increased dramatically. But this isn't to say that Republican judges issue decisions that are less robust than Democratic judges. What it does tell you is that the party affiliation of those judges more closely resembles the party affiliation of the governor. So this brings me finally to areas where I think the literature is somewhat lacking and areas where young lawyers like me might have to do a little more work. So I think there are two areas where the literature could be improved. The first area is a deep dive into the evaluative criteria one would use to assess judicial performance. Now, this is really, really hard because asking when is a judge doing a good job necessarily asks a deeper question of what is the proper role of the judge in American society. You might think that the proper role of a judge is to respond to, at least in some degree, the popular will, in which case you might prefer elections. If, on the other hand, your vision of the state's judiciary is one that wishes to insulate judges from the popular will when it's legal and necessary to do so, you'll have a different idea. However, I do think there ought to be at least an attempt to establish some sort of quantitative evaluation of judicial performance. There have been some attempts at this. For example, a paper that was published by someone named Salakar discovered that in appointive systems, judges in those systems are cited more frequently by other circuits. They're cited more frequently in law review articles. This suggests that their opinions are more clearly written or more persuasive, and they're disciplined less frequently by disciplinary bodies, suggesting that they more closely adhere to norms. However, this only scratches the surface, and I think a really interesting paper in the future could be one that really, really tries to assess judicial performance across different systems. That's obviously a challenge, and I think it's been a challenge for many, many years. One of the footnotes in our paper was from Professor Tarr, who I know has written something about this. The second area of improvement is, I think, a narrow examination of how retention elections specifically affect judicial behavior. The Brennan Center for Justice published a literature review that looked at 10 different studies and found that campaigns against judges who are running in elective systems are harsher sentences when they're labeled as being soft on crime, and that spills over into all sorts of cases. So if you are accused of being soft on crime with respect to sex crime, the data suggests that the judges facing elections will actually issue harsher sentences across the board because it's difficult to predict when the public will be upset at what is perceptibly, or to the public apparently, a lenient sentence. However, the data haven't really explored in detail that effect on retention elections specifically. The Brennan Center looked at some retention systems and found an effect that I think is somewhat tenuous. So given the fact, I think the underlying kind of message here is we're currently witnessing a campaign to unseat a judge this year who received a positive recommendation from the council. If that campaign is successful, it will be the first time in Alaska's since 1975 that a judge has lost his or her retention election despite receiving a positive recommendation from the council. I believe that that may have consequences. I won't come down either way and say it will or it won't, but it's certainly a possibility, and I think future areas of research should examine that possibility. And that's the end.
Wow, so that was super impressive. And I just want to thank Brett for his presentation and laying the foundation. Can everybody hear me? Okay, so laying the foundation for my presentation. First of all, I'd like to thank Terry Carns, who's a co-author of our article that's going to be published as part of this symposium. She's been a wonderful role model and colleague through my 17 years, and also Suzanne DiPietro, the executive director of the council, who's been a great mentor to me and an integral part of this process. So we're going to bring it down a notch because we've had a lot of discussion of the theoretical underpinnings and the principles surrounding the constitutional goals of both the Constitution overall and in Alaska and in the merit selection system. But how does it really work? You know, the delegates, when they convened the convention and presented the judiciary article, they wanted two things. They wanted a system with fair judges, fair and impartial judges, because they had been coming out of a system of territorial judges who they did not believe applied the law in a fair way all the time. And they were also concerned with the competency of these judges, who are often political appointees from places like Ohio and Washington State, where they didn't know Alaska, they didn't know what concerned the citizens of Alaska. They were political hacks sometimes, and they just really didn't care. They didn't do their jobs. And so they wanted a workable system, and they wanted fair judges. And there were two main concerns at the convention. And the first was, what kind of system do we want? And the delegates, they presented, the Judiciary Committee delegates presented a system of merit selection to the body as a whole, and then there was a lot of discussion. McNeely's conversation was part of that. But they voted overwhelmingly to adopt the merit selection system. And the second concern, they went through all the articles and passed them pretty summarily after that concern had been addressed. But the one hang-up they had, the only other hang-up they really had about the judiciary article, is what qualifications should judges have? Should they should the Constitution address whether they should be in practice for X number of years, how old they should be, what kind of experience should they have had? And they ultimately came down on the side of, we're not going to really talk about that. We're going to require the council to present at least 2 names to the governor, but we're going to leave all the details to the Judicial Council. We're going to leave it to this body to decide. And they even talked about, during the convention, they talked about things like, well, this is, we're coming out of a territorial system, but things are going to change. The number of lawyers is going to change. People are going to come and go. Should we really address the fact that, you know, we shouldn't allow a person who isn't from Alaska to become a judge? And so they left all these details to the Judicial Council to figure out. And this has brought about a system of the implementation of those goals of a fair judiciary and a workable system that has been both forward-thinking and very flexible and adaptable to both progress and the current council members as a reflection of our state citizenry. And it's really been an amazing system to watch, especially over the course of 20 years that I've been on the council, and Terry has been, or not on the council, but working for the council. And Terry Carns, my co-author, has worked for the council for
since 1974.
A lot of years. And so we've had the opportunity to both observe and participate in the adoption of a system that has both remained the same and has been developed and implemented in different ways throughout the years. So after statehood, after the Constitution was adopted and statehood was implemented, in the very first year, in 1960, Governor Egan called for the first meeting of the Judicial Council, and he appointed the three lay members, the three public members, and the Bar Association appointed the attorney members. Interestingly, they did not yet have a Chief Justice, so one of the lay members acted as chair. And at their very first meeting in 1960, they discussed how the system would be put into place. And they said, well, we'll have to have an application or nominations for people who want to be judges. And then we'll have to get some information about them. And the people that they turned to, of course, for information about the applicants, the thought was to involve their peers. And this was a discussion that they'd had at the Constitutional Convention when they were talking about what the composition of the council would be. They said, well, we have to have lawyers on the council because they know their peers the best, and they can be the best judge of who would be good judges. So the first council said, okay, so we're going to have the people nominated to the council, judicial applicants. The initial mechanism was that people would use a nominating petition instead of an application. And so their peers would nominate them, or they could self-nominate themselves for consideration by the council. And then we'll ask their peers. So they implemented this survey or this system of asking the bar for their opinions about how good these applicants who wanted to be judges were, so that the bar could reflect on that and give commentary. And so from the very first meeting, laid down the foundation and the construct of how these people would be judged and how they would proceed through the process. The council received the applications, they conducted the bar poll and received information about the applicants. They met, they talked, and they voted. And that's basically the system we have today. It's been refined, but it's a stable system, and it's been a very useful tool for the council. I'm just going to go through some of the processes that the council has used and is currently using, and we'll go from there. So from the very beginning, they noticed up the vacancy. They sent out notice to the bar. They received applications. And the application is very different now than it used to be. They used to just have a name, and of course the bar was like 50 people then. So everybody knew everybody, but now there's a 40-page application. It asks all manner of questions about a person's background, legal history, their experience. It asks for a writing sample, and asks for any additional information about community activities, especially, and then our work starts. We review the applications, and we look for any, concerns that might arise. We do reference checks, we do background investigations, we look at the bar surveys and see if any concerns crop up there. And then the bar survey has changed quite a bit over the years. They used to just send out a poll. Well, do you think this person's good? Do you think this person's not good? And it's gone back and forth in the qualities and characteristics that they have looked at. But they currently we ask about 5 things: professional competence, integrity, judicial temperament, fairness, and suitability of experience. And then there's kind of this overall, professional qualifications, and that turns into all things totaled up. What do people think about their peers? And it gives a good quantifiable, somewhat subjective, because you're asking people what they think, but quantifiable method for the council members to look at to determine how good, in a relative sense, the applicants are. And there's different ways that the information has been analyzed over the years, but it basically comes down to one tool. And I want to emphasize this a lot, because sometimes there's a perception that the bar survey drives the decision-making of the council, and it really doesn't. The council considers all of the materials in front of it, gathered from both the application, the bar survey, all the public information, and I'll talk about that in a minute. But the bar survey is one tool among many that the council members utilize to make their decisions. It's an important tool. It's one that was, information from the bar was deemed critical by the constitutional delegates for the development of a merit-based system, because you have to know how good the lawyers are to know who the good judges will be. But it's not the end all. And we recognize that the bar survey can be manipulated and skewed in some respects by who's responding to the bar survey and what their interests are. So we do break down and look, and the staff breaks it down and looks at the response rate. It looks at who's responding and what concerns are reflected in the responses to the bar survey, and also what underlying agenda might be there. So it's important, but not an end-all tool. And then an important process of the council is not only soliciting information from the bar as a whole, but also from people who have worked directly with the applicants. So we send out council questionnaires, which are directed to people who have very recent experience with the applicants and have worked on cases with those applicants in the last. We try to get people, from about the last 5 years. That's not always possible if the people haven't been in litigation, if the applicants haven't been in litigation. But we try to capture as much information as we can, because more information is better, and the more sources of information is better. And so we talk to the bars, we solicit information from the bar as a whole, we solicit information particularly from people who have worked with the applicant, and then we go back and we hold public hearings at every place where there's an open vacancy. The council travels to that place, interviews the applicants, and we solicit information from the community, because their experience about their community, about what their community needs, about what kind of person would be a good reflection of that community is critically important to the council members. It's interesting listening to the sort of philosophical and principles of this, the constitutional underpinnings, but it's also important, and that's kind of sort of a top-down approach, but it's very critical to the council members that their decision-making is a ground-up approach. They look at who these judges matter to, and the judges matter to this community, so the community concerns are vital. So hopefully, it's our goal that we get community participation at these public hearings that we hold. And also we solicit information from the public as a whole through our website, through letters. I receive phone calls. I love receiving phone calls from people who are interested in the judicial selection system in Alaska, so that I can talk about the process and also receive people's concerns about the process and bring those to the council members, so that can be a part of their decision-making process. Now, I've mentioned the interview a couple times. Council members, as I said, they go out and they interview. They interview every single person who's applied, which is somewhat unique in our system. I've never applied for a job that every single person gets an interview, but in our process, we want to hear from everybody. And in fact, it's a good way to receive commentary from the bar. Even the people who aren't selected, who aren't nominated, bring so much information and experience to our table that it becomes part of the council members' entire body of knowledge about who would be a good judge and who wouldn't be a good judge. Am I running over time? Okay, so we've talked about the interview. Everyone gets interviewed, and we'll talk a little bit about the criteria. As Brett mentioned, the bar survey reflects, we've got professional competence, integrity, fairness, temperament, judgment, legal life experience, and these. By the way, these selection procedures are no mystery. They're on our website. They've been published in every council report since statehood, the development of them. And then I just want to say one thing about the most qualified standard. It's a super important standard. If we want to take more questions about it, I'd be happy to talk about it. But it's a relative determination. Who is most qualified, who is the best available timber, is a relative standard based on all the candidates or all the applicants who have applied, the position that's applied for, and that goes back to that community standard, and the community in which the position is located. So all of that goes into the mix, into deciding who is the best and most qualified and able to serve the judiciary for Alaska. And I don't have time to talk about everything I want to talk about, but I'm happy to field any questions or talk at the break.
Well, thank you. Thank you very much.